Greetings, good afternoon. Yat bit anin shlosh gazo bashishchin na kaida net dashanale dot kachini dashache. Shije yaha Linda Benali. My name is Linda Benali, and I just introduced myself in the Navajo language following Navajo Kinship Protocol. I'd like to thank you for joining us today for our panel on Indigenous Peoples Diplomacy at the United Nations, a contemporary and historical perspective sponsored by the American Bar Association, an accredited non-governmental organization at the United Nations. I am a member of the ABA's Representatives and Observers to the United Nations, which is led by ABA UN Representative Paulette Brown. The UNR Committee's work is supported by resources of the ABA Center for Global Programs, Rule of Law Initiative, and the Center for Human Rights. Paulette Brown, who is the former president of the American Bar Association and the current chair of the ABA UNR Committee, will make concluding remarks at the end of our program. She has tremendous knowledge and expertise in diversity programming, and we are very fortunate to have her with us today. The American Bar Association is among the largest voluntary associations of lawyers and judges in the world. We work for just laws, fair legal processes, access to justice, respect for the human rights and dignity of all. The role of the ABA is to help inform the global discussion, particularly as it relates to international legal frameworks, the role of the legal profession, and promoting a fair, impartial, and independent judiciary. The ABA formed the UNR Committee in 1999. That committee has helped plan events that occur alongside United Nations events, such as the UN Commission on the Status of Women and the UN Global Compact. In fact, in 2012, the ABA contributed to a UN General Assembly declaration establishing an agenda for strengthening the rule of law. Specific to our topic today, however, the ABA House of Delegates passed Resolution 107D in 2022. That resolution urged federal, state, local, territorial, and tribal governments to endorse and implement the United Nations Declaration on the Rights of Indigenous Peoples. You will hear more about the UNDRIP from our presenters, and you'll refer to it as either as UNDRIP, the declaration, but it's certainly a very important international instrument to Indigenous peoples. For 80 years, the United Nations has worked to maintain global peace and security, provide humanitarian assistance to those in need, protect human rights, and uphold international law. The UN was founded in the aftermath of the World War II, with the UN Charter being signed in June of 1945. That charter was then ratified by member states on October 24, 1945, and the UN was officially established. The webinar that's being held today is being done so in recognition of the UN's 80th anniversary. It will highlight Indigenous Peoples Diplomacy in the International Forum dating back to 1923, before the predecessor of the United Nations, the League of Nations. We are very fortunate to be joined by renowned experts who will address the historical framework for recognition of Indigenous peoples worldwide within the United Nations body. And certainly it's a work that still is in progress in contemporary times. However, the message remains the same. Indigenous peoples are neither states, nor are they international organizations or NGOs, non-governmental organizations. In the United States, we are peoples with a distinct political relationship with the national government. We have tribal languages, cultures, and worldviews as declared in the United Nations Declaration on the Rights of Indigenous People, an international instrument that further ushered in international Indigenous diplomacy in the international forum. The webinar today is being recorded and will be made available by the ABA in the future. It is now my pleasure to introduce Lauren Van Schilfgaard, who will be moderating the panel of experts on Indigenous international diplomacy. Lauren Van Schilfgaard is a citizen of the Cochiti Pueblo. She's an assistant professor of law at the University of California, Los Angeles. Her research branches into many areas. However, it focuses on tribal sovereignty and federal Indian law, She previously was the San Manuel Band of Mission Indians Tribal Legal Development Clinic Director at UCLA Law, wherein she supervised live client projects concerning tribal governance and justice systems, ethics, cultural resource protection, voting, child welfare, and much more. She is also the previous co-chair of the Native American Concerns Committee of the ABA Civil Rights and Social Justice Section. Professor Van Schilfgaard co-led the effort for the ABA to adopt an official policy position that I mentioned earlier that focused on United States action to prepare and implement an action plan to achieve the objectives of the UN Declaration, which included consultation and cooperation with the Indigenous peoples of the United States. Professor Van Schilfgaard, I'm so pleased that you were able to join us today, and I will turn it over to you to finish out our program to moderate our panelist discussion. Thank you so much.
Thank you so much, Linda. It is such a pleasure to be here. Thank you to all of our participants that are joining. I am calling from Burbank, California, the traditional homelands of the Fernandino Tataviam and the Gabrielino Tongva. I feel like I have been roped into this work sort of forcibly and against my will, in part because I didn't really understand what the value added was for international rights. In many ways, I feel like I'm still working with this, but I'll say from my own personal position, one of the many things that learning from these three experts has done for me is sort of crack open my mind. Working within federal Indian law, it's pretty easy to get bummed out about the trajectory of the legal arguments, the narrowing of the space in which you can advocate for Indigenous rights. And it feels like within the international sphere, after centuries of advocacy by Indigenous people, we're starting to see the emergence of an entirely new framework. International Indigenous rights have really expanded my own conception of what's possible, and I think is starting to do that for a lot of people. I don't think I'm alone in this. It is now a really exciting landscape for me, just from an idea perspective. But of course, ideas rarely, if ever, operate in isolation. They tend to branch out and inject themselves into all sorts of actual policy, advocacy happening on the grounds, both within international spheres, certainly within the UN, within regional international bodies, but also within tribes. I find this an incredibly exciting time to be engaging this, making this panel all the more timely. I am compelled to note that all of our speakers today are participating in their personal capacities. Their views should not be taken to reflect the views of their employers, nor the American Bar Association. Stands for me too, even though I remain excited. I really can't speak highly enough of our three speakers. This is truly a who's who of international Indigenous rights. And so with that, I'm going to start it off by introducing our first speaker, Professor Kristen Carpenter. Professor Carpenter is the Council Tree Professor of Law and Director of the American Indian Law Program at the University of Colorado Law School. Professor Carpenter was appointed to the UN Expert Mechanism on the Rights of Indigenous Peoples as its member from North America from 2017 to 2021. She also served as a senior advisor to the US Secretary of the Interior from 2023 to 2025. Professor Carpenter is a justice of the Shawnee Tribe Supreme Court and co-director of the Implementation Project with colleagues from the Native American Rights Fund. She's a graduate of Dartmouth College and of Harvard Law School. Professor Carpenter.
Thank you, Lauren. I appreciate the introduction and also the kind invitation from Linda, Paulette's presence and leadership, and sharing the panel with Carla and Aaron, who are longtime friends and colleagues in this space. It's really wonderful that the ABA has become active in the field of Indigenous peoples in international law. And I'm glad to have the opportunity to share with you some work I've done in some different capacities. I'd also like to recognize some folks on the meeting, including Sue Noe and Danielle Poirier from the Native American Rights Fund, with whom I work very closely in the implementation project, which folks have mentioned, and Hannah Aders, who is my fellow at the University of Colorado, and other friends and colleagues who may be here as well. So I understand that my role here is to give an introduction or an overview of the topic regarding Indigenous peoples diplomacy at the United Nations. And I'm trying to center it somewhere within the history and contemporary issues, although recognizing that Carla will go further and deeper back into the history, and Erin will go further and deeper into some of the contemporary issues. And so I think I'm really just teeing up some exciting folks who will follow me. As an initial image, I just wanted to share, especially for a US audience, a picture from the United Nations DESA website, which is a mosaic of Indigenous peoples from around the world. Many of these snapshots are people we know and we work with at the United Nations, friends and colleagues. And within the United States, as you may know, there are 574 federally recognized tribes, several million American Indians, Alaska Natives, Native Hawaiians. But around the world, there are hundreds of millions of individual Indigenous people and peoples collectively, really in almost every country around the world. And these are the individuals and peoples that we have the privilege of working with in solidarity at the United Nations. And I think I'm going to begin my story with an image next of the United Nations itself in Geneva, which is on the right with the flags. And the flags are of nation states, not of Indigenous peoples themselves. And one of the key observations that many of us have had to come to terms with is that when we're working at the United Nations, we are working with a state-centric institution. International law is by definition the law that governs relations among nation states in the United Nations, states that are members of that organization, of which there are 193 or 194, depending on how you count. But since its inception, and as Carla will show even before its inception, Indigenous peoples have been asserting a role in international diplomacy at the United Nations and other international organizations. And Linda mentioned that the UN was founded after World War II to promote peace, humanity, and security. And my understanding from Indigenous peoples who seek to participate at the United Nations is that they are just as interested in those global concepts of peace, humanity, and security as anyone else. And so they have asserted a role in diplomacy, and in particular in the human rights framework and the culture around a human rights framework, to make sure that they, as individuals and as peoples, are able to be protected and to be able to shape this system. At the left, you see individuals from Indigenous nations, especially from North America, who participated in UN meetings in the 1970s, and literally asserting a place at the table in those deliberations and negotiations. Lauren teed up the question of why international law, and this is a question we often get in the United States when we practice in this field. And I wanted to show one answer to the question, which is that Indigenous peoples, their advocates, their lawyers, are already increasingly at the table in international law. So sometimes the question is not so much why, but how. And we're really at a stage of advocacy and diplomacy where the issues are so clearly implicating Indigenous people's concerns that we would be facing, and our clients would be facing, incredible injustice if we didn't have a role in, for example, the climate change setting or in understanding how the US Department of State is representing Indian tribes internationally. But if we look at it with a finer grain, perhaps, I think about why international law, when I practice and teach federal Indian law, through a few lenses. And one is that certain matters are international by nature. You really can't practice them without dealing with the transboundary or global issues. And so, for example, the repatriation of Indigenous peoples' sacred objects or human remains. For hundreds of years, those items have moved across not only national but international spheres, such that Indigenous peoples from the United States, in order to practice their religious and cultural traditions, sometimes must engage in international diplomacy to recover their ancestors, to recover the cultural and religious items that are so important to them. And we could go down this list. Needless to say, tribes, the Yaqui people in the Southwest or Haudenosaunee people in the Northeast, their very territories are now cross-boundary. And so international law implicates everything from family relationships to religious practices. Sometimes we hear stories about people having to cross international boundaries to go to the grocery store. It's just, part of daily life, but it's incredibly affected these days by international law. I won't go through the whole list except to say that multinational resource development is an issue on many tribes' minds, and quite often the mining companies, one current example is at Oak Flat in Arizona, but the mining companies that are seeking to extract resources from lands within Indigenous peoples' traditional territories are owned by companies or even governments that are located in countries around the world. So there too, it's almost impossible to do advocacy to protect tribes' rights and interests without international dimensions of it. And then a second category, this is my list on the right, of issues that arise within the United States that really are just calling out for human rights reform. And I think Lauren's comments went to this point. Some of my own desire and need to engage in international law came when I was working on Indian child welfare cases and sacred sites cases within the US courts. And quite often we hit a glass ceiling or a brick wall of advocacy where basic rights, for example, to take care of one's children or to engage in religious freedoms are not always protected by the US courts. And clients would often say, what's next? And when you reach the end of the line in the United States, there needs to be a what's next. And sometimes turning to international institutions for further remedies or in international frameworks for reform-minded thinking can really open up avenues of advocacy that we don't have in the United States. In terms of some baseline instruments and baseline institutions, I wanted to share some slides. Linda already mentioned the UN Charter, which is the founding document for the United Nations, and it sets out the way in which it works as an organization, a member state organization. And I should say the UN isn't the only organization in which Indigenous peoples do international advocacy. Sometimes they encounter each other at regional bodies, the Organization of American States, or on a bilateral basis. For example, the Yaqui people, for example, and the Sami people of Sweden or Norway. But our talk today is really focused on the UN, and so I'm focused there too. Some of the other foundational human rights instruments include the Universal Declaration on Human Rights, and then the conventions or covenants that put the Universal Declaration on Human Rights into practice. And those of you who practice human rights are probably well aware of these instruments, but to state it in its most basic form, these instruments recognize the bare minimum obligation of states to ensure that individual and increasingly collective human beings can live lives of dignity. So rights to life, rights to religion, rights to housing, to non-discrimination, increasingly a right to a clean environment. These are coming up and articulated under these instruments which apply to all people in the world. Now, one challenge has always been that Indigenous peoples, as Linda said, for a long time didn't quite fit in the paradigms that these instruments set forth. And so while this is a state-centric system of governance, and by states, I mean nation states or countries, going back to the Universal Declaration on Human Rights and trying to ensure that the horrors of World War II would never happen to individuals. For example, the Jewish people who experienced the Holocaust in World War II, the Universal Declaration on Human Rights placed rights of individuals and obligations of states to protect individuals, but didn't clearly articulate how those should apply to groups, and in particular to Indigenous peoples. And so the UN Declaration on the Rights of Indigenous Peoples was a goal that different Indigenous peoples, a little bit before my time, spent decades advocating for. And what it does is to put these universal human rights in an Indigenous peoples context, to recognize both individual and collective rights, to further key norms like the self-determination of Indigenous peoples, their equality, and also to contextualize how some of the universal human rights, like to religious freedom, apply in an Indigenous peoples context. And you might note, for example, that enjoying the right to religious freedom for Indigenous peoples cannot fully be met by going to church or going to a mosque or being able to have internal religious beliefs, but must also include access to sacred places in the natural landscape, the ability to practice collective rituals, to use medicinal plants, and other aspects that have often been ignored or even violated by many national governments, including our own. So while the UN Declaration on the Rights of Indigenous Peoples was adopted in 2007, since then, Indigenous peoples and some states around the world have really been focused on its implementation. And I think that's the challenge for my generation and the generation that follows, which is that our predecessors were able to negotiate, draft, and have accepted the UN Declaration on the Rights of Indigenous Peoples, which is an amazing proclamation of rights. And at this point, all 193 countries in the UN are on record as having committed to achieving the aims of the declaration. The US has expressed its support. But how do we put it in practice? And one of the things that we're very focused on in the implementation project, which is our joint initiative between the University of Colorado and the Native American Rights Fund, is exactly that. How do we put these rights into practice? And for us, the model is really about simultaneous and mutually informative engagement in tribal, domestic, that is national or federal, and international settings. Now, today we're focused on the international, but I would definitely be remiss if I didn't mention the tribal and domestic settings because they inform everything that happens in the international bodies. My time is coming to a close, and so I'll just leave you with some images of the United Nations itself and perhaps a tee-up with respect to where we're doing a lot of the contemporary work. So here's a graphic representation of the UN. This is the simple one. I have even a more complicated one after. But you'll see or you'll learn through some of these presentations that most of the Indigenous peoples' work takes place within or in bodies that are subordinate to the General Assembly. And so, for example, the UN Permanent Forum on Indigenous Issues is under the Economic and Social Council, and several other UN mechanisms are under the Human Rights Council, which was itself created by the General Assembly. This is an incredibly complicated structural element and slide, but it covers all of the treaty bodies as well as the Indigenous peoples mechanisms, where everybody on this call is doing quite a bit of our work. Perhaps a little bit more digestible is this image with the three mechanisms: Special Rapporteur, Permanent Forum, and Expert Mechanism on the Rights of Indigenous Peoples, where we, our friends, our colleagues, our clients are appearing in Geneva and in New York to advance diplomacy. on human rights, as well as several of the UN agencies, UNESCO and WIPO, the World Intellectual Property Organization, where quite a lot of diplomacy around cultural rights, intellectual property rights, and other matters is occurring. I think having shared with you some preliminary thoughts, I will pass the floor to the next speaker and be glad to engage in dialogue more with all of you. Thank you.
Thank you so much, Professor Carpenter. That was great, including the very intimidating chart about what exactly is made up of the UN, which my understanding is right. That's just like a piece of the UN. Yeah, very approachable. However, I want to keep us slightly on track. I note that there is a question posted in the Q&A box. Please feel free to post additional questions. While I cannot guarantee that we'll be able to get to everything, we'd love to have you engage. But in the meantime, I'd like to bring up Carla General. Carla is an associate legal counsel for the Seneca Nation, a federally recognized Indian nation of 8,500 members, where she works in-house as a governmental attorney. Before moving to Western New York in 2017, Ms. General infamously worked as an attorney with the Indian Law Resource Center in Washington, D.C. to promote and defend the rights of Indigenous peoples in North, Central, and South America, as well as to raise awareness of Indigenous peoples' rights to self-determination of their lands and resources and to combat systemic injustice. She is a graduate of the Syracuse University College of Law and the Maxwell School of Citizenship and Public Affairs, where she earned her JD and MA. She received her BA from St. Lawrence University in Canton, New York. She is Deer Clan, a citizen of the Mohawk Nation, and was raised on the Akwesasne Mohawk Territory. She serves as Secretary of the Communities of Giving Legacy Initiative for the Community Foundation for Greater Buffalo, and as Treasurer for the Federal Bar Association's Indian Law Section Board. Carla, we turn it over to you.
Yeah, Lauren, Zego, Sawagwego, Gauniosta Yungets. Hello all, my name is Carla Gauniosta General, and I hope you're all well today. First off, thank you to the ABA's UN Representatives and Observers Committee for the invitation to present today, and to my fellow presenters and participants for your presence. I am so honored to be here. I have a PowerPoint I'm going to try to share right now, so just bear with me. Okay, it should be up. The bulk of my presentation today will be focused on Indigenous peoples diplomacy at the UN in a historical context, specifically through the lens of my great-grandfather's work. In the 1920s, Levi General, also known as Deskahe, was selected by his people as Speaker of the Haudenosaunee, or the Six Nations Confederacy, to seek justice from the international community in the 1920s. Specifically at the League of Nations in Geneva, Switzerland. He worked tirelessly through his life to gain international political recognition for the rights of the Haudenosaunee Six Nations by winning support from smaller nations of the world. And his work culminated with a formal petition for membership in the League of Nations in 1923. The League of Nations was the precursor to the United Nations. It was founded on January 10th, 1920, after the First World War, and was headquartered in Geneva, Switzerland. The goal of the League was to prevent future wars through global governance by expanding the rule of law and giving voice to smaller nations and strengthening human rights. It had 58 members at its strongest, and you'll see on the map as it populates. However, the US was never a member. They never joined, despite US President Woodrow Wilson being an early architect of the vision of the League. In 1920, Canada joined the League of Nations, and while Canada was espousing the protection of smaller countries abroad in Geneva, it was violating the rights of Indigenous peoples at home, including my great-grandfather's nation, which was located just outside of Toronto, Ontario, on the Six Nations territory. Canada was attempting to force traditional Indigenous governments to conform to Canadian law regarding what a government should look like and what the rules for property ownership should look like. Canada did this through federal legislation known as the Indian Act, which is similar to the Indian Reorganization Act of 1934 that happened in the United States. Canada sought to impose a new government for the Six Nations with new rules for property dispossession and application of Canadian criminal law against the Six Nations people. After exhausting domestic remedies in Ottawa, the Six Nations selected Desgahe as their speaker to seek justice from the international community at the League of Nations. In 1921, Desgahe first traveled to London to meet with King George V, as Canada was still a subject to the British Crown at that time, to persuade them to recognize Six Nations sovereignty. In 1922, Desgahe wrote to Queen Wilhelmina of the Netherlands and traveled to Washington, D.C. to speak with the Dutch embassy, where he requested presentment of his petition to the League of Nations because, quote, the Dutch were the first palefaces to keep faith with Indigenous peoples. When these efforts failed, Desgahe and his attorney, George Decker from Rochester, traveled in 1923 to London, Paris, Geneva, and other cities throughout Switzerland and Germany, spending more than a year and a half trying to win support for international intervention to help their community. Eventually, through all of his diplomatic efforts, over the course of 18 months or so, Desgahe was able to win the support of 5 smaller countries, including Estonia, Persia, Panama, Ireland, and the Netherlands for his case. Desgahe's appeal to the League culminated in a request for membership in the League for the Haudenosaunee for the purposes of submitting their dispute with Canada for international review and intervention. The government of the Netherlands forwarded his petition to the League's Secretary General, and Persia even sponsored a formal motion that Desgahe's request be placed on the League's agenda. This was vetoed by the more powerful countries, Great Britain and Canada. One major problem with how the League functioned was its reliance on consensus decision-making, because the stronger members were not willing to give up veto power to smaller countries. In his petition, and these are original documents in the archives of the UN that I took photos of when I was there. In his formal petition, you'll see the August 6, 1923, Desgahe explains to the League that the Haudenosaunee Confederacy are self-governing nations and have been for centuries, and are in fact part of the oldest League of Nations, with a status recognized through treaty making by the governments of Great Britain, France, and the Netherlands, which includes their successor states, the US and Canada. His petition advocates for the maintenance of mutual peace, justice, and for recognition of the Six Nations as an independent state with the right to be governed by their own laws and to freely travel upon their own homelands. While Desgahe never addressed the League directly, his appeal for justice will forever remain part of the history of the long Indigenous struggle to achieve a seat at the UN, and will forever remain in the archives of the League and the UN in Geneva. With Desgahe's absence from home, Canada was eventually able to impose elections upon the Six Nations using force and arms, and by Canadian proclamation in October 1924. Desgahe returned to the US very ill in January 1925. He was vilified by the Canadian government, who prevented him from re-entering Canada, prevented his medicine people and family from seeing him, and he died at a friend's house on the US side of the border on the Tuscarora Reservation, which is about 45 minutes from where I'm located now. His diplomatic efforts to preserve the rights of his people came at a great cost and a great personal sacrifice to himself and his family. It is hoped that he died knowing that the first true League of Nations, the Six Nations, was still alive and would continue to defend the rights of not only the Haudenosaunee, but of all Indigenous peoples, including our right to live under our own laws, on our own lands, and to practice our culture and faith in our own ways. Since those dark days, there have been other efforts to persuade the international community to recognize, support, and protect Indigenous peoples' rights. 80 years ago, in 1945, the UN was born after the League was dissolved. Then in 1977, delegations of Indigenous leaders went again to the UN to seek justice for the theft of their land, the destruction of their environment and resources. That year, the UN held a conference on discrimination against Indigenous populations in the Americas, and Indigenous peoples introduced the first draft declaration on the rights of Indigenous peoples. Indian Law Resource Center and attorney and founder and member of the Citizen Potawatomi Nation, Tim Coulter, drafted the main points of this declaration, which would be negotiated amongst member states of the UN and Indigenous peoples representatives for the next 30 years. Until 2007, when the UN General Assembly would adopt a version of the Declaration on the Rights of Indigenous Peoples that represented the culmination of all of those negotiations. The importance of the declaration cannot be overstated. There is now global consensus that Indigenous peoples have the right to exist, self-determine, and self-govern, a right that will be honored in perpetuity by the international community. This was the Skahe's vision realized. However, there do remain some challenges in the UN with implementation. In 2014, the UN World Conference was held to address some of the shortcomings of the declaration and its lack of implementation by member states. While the declaration recognizes the right of Indigenous peoples to their own governments, lands, cultures, and languages, it does so within the current state of affairs, and the declaration provides that recognition of these rights shall not interfere with the territorial integrity of member states. Prior to the World Conference in 2014, dozens of preparatory meetings were held amongst Indigenous peoples to come to agreement on several priority areas. During my time as an attorney at the Indian Law Resource Center, we worked with 150 tribal nations in the US and Canada to identify priority areas for action that would help implement the rights of the declaration. These decisions were incorporated into the final outcome document of the conference, which was adopted by General Assembly resolution, which is the highest action that can be taken. Eventually, we were able to get a commitment from the UN to transform the expert mechanism to expand its mandate to become an effective implementing and monitoring body for the UN Declaration by increasing the number of experts and expanding its mandate, to urge all member states to adopt a national action plan to implement the UN Declaration, and to secure new rules that would enable the enhanced participation of Indigenous governments at the UN. Full participation of Indigenous governments in decisions and meetings of the UN remains a substantial hurdle to exercising our international human rights. The existing rules of accreditation provide NGOs the opportunity for status at the UN, but no such rules currently exist for Indigenous governments. Without a special invitation, Indigenous governments cannot even attend or observe sessions of the Human Rights Council or the Third Committee of the General Assembly, which adopt annual resolutions on the rights of Indigenous peoples. Nor can Indigenous governments participate in any meetings of the Commission on the Status of Women or other functional commissions of the Economic and Social Council, which regularly address matters affecting Indigenous peoples. We sought to change that by winning a decision at the World Conference to create new rules acknowledging the political and legal status of Indigenous governments with enhanced rights of participation. From 2014 to 2017, the United Nations President of the General Assembly held several consultations and interactive dialogues with Indigenous representatives on what these new rules for participation should look like for Indigenous governments. The Third Committee of the General Assembly eventually introduced a draft resolution for consideration by UN member states. After multiple revisions and negotiations, states reached an impasse on the question of a no objection procedure, a mechanism that would allow a member state to secretly exclude an applicant from being credentialed without having to provide any reason whatsoever, essentially a veto power. Because this process would have been secret, the no objection procedure would effectively shield the objecting member state from political repercussions and public scrutiny. This is precisely the kind of tactic that kept Skahe from addressing the League of Nations in 1923 and was a non-starter for Indigenous peoples in 2017. With no agreement in hand, the General Assembly decided to kick the can down the road and adopt a compromise resolution. And that's where we're at today. Opportunities for Indigenous advocates at the UN. In 2025, we have several opportunities to improve the participation process. We can put pressure on the General Assembly to finalize a resolution that would create a new process for enhanced participation for Indigenous governments. The latest General Assembly resolution commits to taking action at the 80th session, which opens on September 8th, 2025 and runs through the year. Folks can also encourage member states to implement the World Conference Outcome Document Article 8 to develop and implement national action plans, strategies, or other measures to achieve the ends of the declaration. There's an NCAI resolution that provides 3 points of recommendation to encourage the US to develop a national action plan, to encourage them to appoint an ambassador for global Indigenous affairs, and to support the full and effective participation of Indigenous governments at the UN. We can adopt and support more resolutions like 107D of the ABA House of Delegates that was discussed earlier, that outlines a process to adopt national action plans to achieve the objectives of the UN Declaration. And I was especially heartened to see reference to working toward more action and enforcement in the Inter-American system, which is another process for those nations located in North Central South America. I just want to conclude my remarks here. I have a few minutes and some contact information. The Skahe Levi General was determined to exercise the rights of the Haudenosaunee and the rights of Indigenous peoples to live under their own laws and practices. He believed in the spirit of Geneva that smaller nations would stand up against injustices caused by larger, more powerful ones. He laid the groundwork for all of us and created a path forward to ensure the continued existence of Indigenous peoples. With the adoption of the Declaration and the World Conference outcome document, there is now global consensus that Indigenous peoples have the right to exist and to exercise our collective right of self-government and self-determination. The hard work remains to ensure that such rights are recognized, respected, upheld, and protected. By providing Indigenous governments a seat at the table, decisions made in international fora will be responsive to the lived realities of Indigenous peoples at home. Indigenous governments are their own best advocates and will be able to raise concerns directly about human rights violations and concerns about environmental issues, climate change, sacred sites, economic development, and violence against women and children. In Diskahe's last public address before his death, he encouraged listeners to stand up and speak and to educate your sons and daughters. I'm encouraged by this panel and its participants on the call today that his words will be taken to heart, and we will all keep educating others to use the UN as a tool and a resource to implement and exercise our rights to self-govern, to self-determine, and to ensure our collective health and wellness for future generations. Yamagoa, thank you.
Thank you so much, Perla. That's incredible. Obviously, you heard all the time, but the through line between you and your great-grandfather's advocacy is incredibly remarkable and hopeful. I know I will have a question later when we get to the question and answer portion regarding how Indigenous peoples should be represented in the UN. So I'll let that linger for a little bit. But first, I am elated to introduce our final panelist, Erin Jones. Erin is a seasoned policy advocate, and I say that with incredible grace, but given your immense travel schedule, it's truly remarkable. Policy advocate and tribal negotiator who serves as Director of Natural and Cultural Resources for the Tulalip Tribes. He is also co-chair of the NCAI International Committee with extensive experience in negotiations at the World Intellectual Property Organization, a multi-decades long forum advocating for the protection of Indigenous intellectual property. He also advocates at the Convention on Biological Diversity. Erin is a member of the Tulalip Tribes and of Snoqualmie, Wenatchee, Duwamish, Malahat, Saanich, and Cowichan descent. Apologies for my mispronunciation. He earned his undergraduate degree in pre-law and political economy and his master's in public administration from the Evergreen State College. Erin, it's such a pleasure to have you.
Thank you, Lauren. Hasla Hail, Hasla Shuda Tabuthed. Good day, everybody. Stay hopes Kadab Teetsta, 12 Chud Deflalip. My name is Erin Jones. I'm from the Tulalip Tribes. And yes, as Lauren said, I many ancestors and related to many people. But a little bit of what I'm going to talk a little bit about that today, just in the context of, WIPO in particular. So, and you can see my screen, correct?
Yes, we can see it perfect.
Thank you. So I'm, a goal I want to have, coming out of this discussion today is just, sharing a little bit about the story that that I've gotten to, step into here at the Tulalip tribes. Tulalip has been going to international meetings, for well over, 25 years. And it all started, with Terry Williams, our late elder, that was our former director of the Treaty Rights and Government Affairs Office, or Treaty Rights Office. But first, I always want to start off with just sharing, to folks where I'm from. So, the Tulalip tribes are the successors of interest to the Snohomish, Skykomish, and Snoqualmie tribes, and other allied bands signatory to the Point Elliott Treaty of 1855. I bring that up a little bit because, we deal with issues all the way from the marine waters and all the way up into the, to the peaks of the Cascade Mountain Range, and a lot of relations and a lot of, other practices that go beyond, our ceded territories of the Point Elliott Treaty. But I just wanted to share a little bit of what Tulalip Bay looks like for you all to see, and then also, a picture of some of the mountains we have nearby. And I, just for my own personal, I guess, reference, is I got to put a picture of my fiance into this on the picture on the right. So she's sitting on the big rock there, but just something I wanted to do as well. Part of what got Terry Williams involved in going to the United Nations and other bodies, in particular, starting with the UN, Conference on Biological Diversity. It came from his time of, working in the Council of Environmental Protection. And it was just a place where he learned about the UN CBD and how Indigenous peoples can get involved there, and learning about how he can get his own tribe, the Tulalip tribes, to be an accredited observer to the CBD, to start participating in those negotiations for just enhancing, restoration, conservation, and sustainable use of biological diversity. So what that kind of started developing once the biological CBD started getting into, negotiations about protection or usage of traditional knowledge, was what is, at risk for us as a sovereign nation when it comes to usage of traditional knowledge. And that really gets at, a lot of these listed things here, but this is not an exclusive list, from art, dances, songs, genetic resources, data and technology tools, even sacred sites, I think that has been mentioned. But, getting to how can we further protect that, from inappropriate and harmful disclosures of our culture, lifeways, any other proprietary information protection from research and commercial misappropriation or exploitation, of our traditional cultural expressions, or even our treaty reserve resources that we collectively hold. And, for the Tulalip tribes, it's, we have many families because of this history with the treaty, and, being successors of interest of multiple tribes. It kind of puts us into, a unique, I guess, examples that we can share of how we, follow our customary laws and protocols to, to practice our culture and share how we protect knowledge, or how knowledge is, used, more openly, or if it's more, used for ceremonies, as well as just protecting against binding policy that infringes, on the rights and self-determination of Indigenous peoples. And it was said before that, the UN is a unique area where you can have that influence on member states, or on country states. And for environmental issues, Tulalip, we have to interact not only with the United States, but also with Canada when it comes to fisheries management and other environmental, marine factors that, and even bird migratory factors that, we want to worry about, that in practicing our treaty rights to fish and hunt. Following the theme of talking more about diplomacy and just kind of getting at, I've entered into doing some international work for the Tulalip tribes, over 19 years, since Terry Williams started practicing, and some of my predecessors, like Preston Hardison and Ray Freiberg. And, and even Ryan Miller. And it's just been a way of like where we could practice our values and demonstrate those to our peers, our other Indigenous, colleagues and representatives from the, 7 sociocultural regions of the world, where we can ensure in our advocacy that, we're protecting our rights, but also finding ways, in our interactions with others, through diplomatically, of how can we also protect areas that are of concern to them, and they might have varying domestic laws they need to worry about, just like we do. And getting to a point where the international text we're negotiating can be comprehensive enough and leave enough, policy doors for us to seek protections that we need, or to seek actions that we need to have domestically or internationally. And, part of a long practice too, I would just want to say, like, from our culture is, there's nothing new about us traveling and sharing our culture and songs with others, as often we would do in the summer months, when we'd go fish somewhere else or gather somewhere else, or, travel extensively to trade. And in kind of more modern day practice, the Tulalip tribes has not only done cultural exchanges, with other Indigenous peoples around the world, but we've also hosted some policy exchanges here at the Tulalip tribes, where we can talk about what our tribal codes look like to some of our visitors. And we've had, people from the Sami Council come visit us, and others as well. It's just been an opportunity to really demonstrate what we do here, in exchange of hearing, what they do in their own domestic contexts, and where do we have ground where we can support one another in advocacy. And so kind of getting into talking about modern context. So with the World Intellectual Property Organization, it was an agency that was founded in 1967 of 193 member states that participate in WIPO today. And the context for it is just to be a global forum for intellectual property services, policies, information, and cooperation. And so the reason why Tulalip participates there largely was through the participation at the CBD. So there was, during the late 90s, there was WIPO representatives that were looking to understand how to address traditional knowledge in the IP sense. And so just before they established the ad hoc committee on the intellectual property and genetic resources, traditional knowledge and folklore, so WIPO IGC, in 1999, Tulalip tribes hosted the WIPO Secretariat on their fact-finding mission, that they were having a mission just to go around the world to learn more about how Indigenous peoples' traditional knowledge systems work, and how it can be, I guess, placed into the WIPO context for seeking protections and being part of negotiations. And so really, once this WIPO IGC became established, the Tulalip tribe, so Terry Williams was very much involved in the beginning, and just going to these meetings with other Indigenous representatives and forming the WIPO Indigenous Caucus. But, there are 2 current remaining instruments that are being explored at WIPO still, and that's traditional knowledge and traditional cultural expressions instruments. So 2 separate instruments that I can get into a little later, but we're looking at potentially trying to find ways to merge those instruments into one, just because of the inherent nature of cultural expressions with traditional knowledge systems. But also, it was kind of a new result we have here is with the 3rd instrument of genetic resources and associated traditional knowledge becoming an official international treaty in May of 2024. So just to start off with our new treaty that came out of WIPO, it's the first WIPO treaty that acknowledges Indigenous peoples' rights, and for contracting parties to achieve the aims of the United Nations Declaration on the Rights of Indigenous Peoples. It includes a mandatory disclosure requirement relating to country of origin for genetic resources and traditional knowledge associated genetic resources, whether that came directly from Indigenous peoples or another, I guess, another source. In addition, there are sanctions and remedies, so there are some teeth to this treaty. And right now the scope of the treaty is only on patents, but with the review clause included in the treaty, there's possibilities for other areas of IP be, to become a part of this treaty. And so it was a long 2-week process. And there are some other folks on this call that have had met shared years of participating in WIPO, and being a part of these negotiations as well. And so we have the 2 remaining instruments, though, of traditional knowledge and traditional cultural expressions going into the new biennium. And really what we're trying to find still with these remaining instruments is how to get a sui generis regime to be adopted and implemented into these instruments. Just because when it comes to intellectual property, there hasn't been a lot of involvement of how our knowledge systems and how we protect songs or how we share songs or who has permission, as an example, how that kind of correlates with the current day, copyright laws or trademark laws. But, there is much more work to kind of get into with TK and TCE's instruments. And, part of just this conversation today is I hope it inspires others to learn more about it, get involved in ways that we can, and just build capacity around these issues, because that is a continued area when we see of challenges in participation in some of these forums like WIPO. It's just not having the ready resources to build that capacity. In terms of like involvement over time with WIPO, has been one of the few committees in the WIPO IGC that has had pretty profound Indigenous participation, in the sense that Indigenous peoples, under the direction of the committee chair, would be allowed to be in different rooms. And I don't like using the word allowed, but in the WIPO rules of procedure, it is the chair of the committee that determines how the meetings are going to function and how they're facilitating the negotiations. But there has been great opportunities for Indigenous peoples to be in closed door meetings with member state delegates and talking through, various issues within the draft instruments. And what I wanted to highlight with, the WIPO Diplomatic Conference that took place in May of 2024 is that there was a lot of inclusion of Indigenous peoples in breakout sessions or in small group sessions, just to negotiate various articles of that treaty, as well as there is inclusion from the president of the diplomatic conference to talk with the Indigenous WIPO caucus, and as well as other coordinating meetings where the co-chairs of the caucus got to participate in kind of those coordination meetings with other major group coordinators. And that presented just a lot of momentum for Indigenous peoples to really shape what this instrument looked like. And there's a long way to go still when it comes to genetic resources associated with traditional knowledge and further protections that, coming from Tulalip, I think I would like to see. But it's one of those, it's a great opportunity, for Indigenous peoples to have a forum that affects them directly, pretty much in any domestic context that we see, and how we can seek protections there. So I don't know if I just kind of rushed through all my slides or not, but I'm kind of at the end of where I planned.
Thank you to all of our panelists. That I know was the distillation of a lot of different information to break it down for us. Really appreciated. I want to note at the top that Professor Carpenter is going to have to sneak out slightly early to go teach class. So we're going to allow her to do that whenever she needs to. Just feel free to drop off. Otherwise, I'd love to post some questions to the panel, pick your brain while we still have a few minutes. I also invite attendees to post any questions that you all might have. We had such one of those, and I thought that might be a nice place to start, especially because you all have like a very impressive grip on the complexities of the UN. And so like with the new WIPO treaty, this is the first WIPO treaty that recognizes Indigenous rights. And I wonder if I'm right in thinking that it's only the second UN treaty that similarly recognizes Indigenous rights, the first one being the International Labor Organization, 169. there might be another, I'd be interested, which is to say there's not a whole lot out there, making enforcement of Indigenous rights really tricky. We had a question in the Q&A inquiring about universal periodic reviews. My understanding is those are tied to countries that have committed themselves to other treaties, like the International Covenant on Civil and Political Rights. A country might then be subjected to like an annual or biannual or whenever a review. But what other enforcement mechanisms are there when a country has committed itself to upholding Indigenous rights, but then violates those rights? Oops. Not a like very technical question. Maybe Professor Carpenter, you want to tee us off, correct all of the errors that I just said?
No, there were no errors, and I'm so glad that you too are teaching Indigenous peoples in international law, because I think that raising a next generation of lawyers to not exclusively focus on federal Indian law as we have for so long, but to include the international and also tribal law as subjects of inquiry really enhances our ability to serve as good advocates and diplomats. And I was really glad that Erin focused on diplomacy in particular as a skill set. We can talk about that more too. There are a couple of other treaties that mention Indigenous peoples. There's an Oceans Treaty and others that I can't think of at the moment. But in terms of implementation, in some ways, that is the $1,000,000 question, or enforcement, as we would probably put it in the United States. And we can think about it in several ways. I mean, one is the overarching question of how to enforce international law generally. And in the United States, that is more complicated than in some other countries. And in a number of places, when a country enters into a treaty and ratifies it at home, that becomes part of the domestic legislation enforceable in their courts. In the US, it's a little more complicated than that. We not only require signature and ratification, but also some express implementing legislation giving rise to a cause of action in the courts. And that's in the best case scenario when we're talking about a treaty. That said, there are plenty of instances where the US Supreme Court and other bodies have referenced treaties that the US is a party to. You've mentioned the ICCPR and otherwise. And also there's nothing to stop the courts from referencing treaties and declarations like the UN Declaration on the Rights of Indigenous Peoples as persuasive or secondary authority. And I won't go into the super technical discussion of customary international law and general principles and so on. But there's a wonderful new chapter in the Cohen's Handbook of Federal Indian Law by Jim Anaya that goes through the latest and greatest on that. In terms of not being so US centric, there are treaty bodies in the international arena whose job it is to monitor states' compliance with the treaties that they sign. So, for example, the Human Rights Committee makes sure that countries are living up to their promises under the ICCPR and so on. And this is, a meaningful way for individuals and increasingly groups and increasingly Indigenous peoples to seek compliance and seek oversight from the international setting. Again, it's a little bit more limited with respect to the US because our country kind of drags its feet on ratifying the protocols. Before I relinquish the floor, I just wanted to say too that our project, the implementation project, and I didn't get to my last slide, but you can see the implementation project here on my background and just Google us. We're all about thinking of different ways to not so much enforce, because that's not typically even the goal in international diplomacy, but through methodologies, including persuasion and coalition building and solidarity and legislation and you name it, to help to bring international rights and norms into domestic settings, whether that's tribal or federal or whatever it happens to be. And we have dozens of examples in our wonderful publications that I think all of you actually on this meeting have worked on. So I can cite all of us for some of these examples, and I just recommend those to everybody here. So thanks.
Thank you, Carla and Aaron. Any other comments on how we might implement and or enforce Indigenous rights at the UN or otherwise?
Yeah, I just want to briefly mention the different special procedures tools within the Human Rights Council. And you can do some of that advocacy remotely. You can reach out to them, submit information, and they all have a bit different mandates. Kristen is an expert on those, but just for instance, the expert mechanism on the rights of Indigenous peoples, some of the work that was achieved at the World Conference was to expand the membership, I think from 5 to 7, and to expand the mandate for them to actually go into countries and seek information and gather on their own accord once they have that mechanism kind of turned on by an official complaint or a request from somebody whose rights are being violated. So I think some of those things, it's not necessarily court order that's going to get enforced, but it goes a long way to start documenting the violations of rights and create a paper trail. And I think the special procedures being one mechanism, and then whatever report gets issued from that, you can take that to the Human Rights Council and make a statement about whatever the report eventually would say about the rights violations.
Please.
Oh, well, when it comes to enforcement, I guess it kind of depends on the rights for me, because I do look at, like, if you look at fisheries management here in Western Washington, the treaty tribes are co-managers with the United States. And then part of that is, we work closely with the Washington Department of Fish and Wildlife in creating what are regulations and what are, I guess, offenses that could be enforced, whether it's, against tribal fishers or non-tribal fishers, or, and there could be cooperative agreements of how things like that are enforced, but I guess, when it comes to larger human rights issues, I think that's an area that needs to be further developed, because when you go into looking at how are rights being violated in intellectual property usage, there's a lot of violations there there's still not a mechanism to fully protect, traditional cultural expressions or symbols from my culture's art utilized in somebody else's medium, or, what they seek to get protected. So it would be an area I'd love to see more people involved in, I guess, workshopping and seeing how we can get it included.
Intertribal human rights body. Let's go. I want to inject one of my questions here that I teed up earlier regarding participation. I know that there's been a lot of discussions recently, both regarding the UN Permanent Forum on Indigenous Peoples, but I think some of these other bodies. Aaron, you mentioned a little bit about your participatory role at WIPO and some of the side events. And as Kristen sort of teed us off, international law is the law of states. It doesn't really have an institutional place for Indigenous peoples. Is the goal to build one? Is the goal to treat Indigenous peoples eventually like states? How are you thinking about how Indigenous people can and should be participating in the UN? And does that have any impact on what you think about how and should tribes be participating within the United States?
I nominate Carla to start this one.
I have a lot of thoughts, no. I mean, at our outset, we were essentially nation states. We had treaties with all the colonizers and with each other. I mentioned we were the first League of Nations. We were the first international intergovernmental organization, the Six Nations Haudenosaunee Confederacy. And different intergovernmental organizations have modeled themselves off of the Haudenosaunee, and regardless of what federal Indian law has narrowed our rights into, I do feel strongly that we are still self-governing, self-determining entities with a collective right of self-determination. And under international law, there's a decolonization process, which largely is inaccessible to tribes today, but the UN is used to evolving and creating space for everybody else except Indigenous governments. And they have created space for observers, for national human rights institutions. There's separate rules, there's separate processes for these types of organizations that Indigenous governments cannot benefit from. So I would like to see a new process for Indigenous governments that does not equate them to non-governmental organizations and put them in the same basket where we have to fight for 2 minutes of speaking time and stay in Geneva for 2 weeks. And you don't know when your time is going to come to raise your issue. So something that accords Indigenous governments with that separate, distinct status that we already have.
Thank you. Others? Please, Kristen.
Well, I was going to defer to Aaron if you wanted to mention anything from the WIPO experience, and then maybe I can just say one thing at the end.
You're putting everyone else on the spot. You must be a professor. So, I largely agree with Carla. There, as representative of the Tulalip tribes at WIPO, we follow our own tribal codes and laws in terms of like deciding who is a representative for Tulalip to go to. So we have a resolution that our board of directors, passes and adopts and signs, and who is on that resolution is who gets to go represent Tulalip and that sovereign voice, at WIPO. So when we go there as an NGO, it does feel a little, neglectful, or, I guess there's just that lack of acknowledgement to show that distinction, and a little more favoritism, I would argue, in some regards, that there might be perception of, looking at other categories of observers a little more fondly than an NGO observer. So it would be a little more interesting for me to know, and it would just be a right, that tribal government should have, or however it's organized in another country, that Indigenous government is recognized. I do know some, depending on domestic laws for other countries, it's hard to get around the NGO status, but I really do hope that we get out of this kind of continued categorization, like Carla was saying, and move into that distinct status with one negotiating at the UN.
If I may, and I really appreciate Aaron and Carla's thoughts and experiences, and this isn't a counterpoint in any way, but given the very meaningful and important critiques of the UN in excluding Indigenous peoples under their own auspices, even before there was a UN, as Carla pointed out, something that sometimes goes unnoticed is that Indigenous peoples, including tribal governments, do register under their own auspices for both the UN Permanent Forum on Indigenous Issues and the UN Expert Mechanism on the Rights of Indigenous Peoples. And through our project, the Implementation Project, we've been supporting more and more tribal leaders who have chosen to go to those meetings, even though it is of great expense and great time and uncertainty, as you've all pointed out, in part because they can make statements as tribal governments. And that is absolutely not true in ECOSOC or the Human Rights Council and so on. But I do want to acknowledge the tribal governments that have taken advantage of some of the procedures under the Indigenous peoples mechanisms. And I think a strand of the movement for enhancing Indigenous peoples' participation at the UN more broadly would like to look at those examples and, extrapolate and expand from them to apply at the UN more generally. It's very powerful to see some of those statements in recent years from the San Carlos Apache tribe and Cherokee Nation and dozens of others. I can't even list them all at the moment. So thank you.
Thank you. We've heard about bye, Professor. We've heard about a couple of different active spots. It certainly felt like the UN Declaration was this watershed moment. I think hopefully we'll reflect on this new WIPO treaty as another watershed moment. Where do you both sort of see like the action right now in the UN? Where is the greatest potential to be advocating for Indigenous rights? Where should Indigenous people like be keeping their eyes on? Aaron.
Okay, I was trying to make eye contact with Carla to say you can go first. It's a little harder to do on Zoom, I guess. But for me, I want to be supportive of where does a tribe want to start? Because not every tribe wants to participate in WIPO right now because of capacity. They might be more interested in health. They're more interested in biodiversity or climate change. And for me, it's just kind of starting with that because I know for Tulalip, in my experience of working with Tulalip with my tribe, Terry Williams was very much in the environmental field. And so that's where we started out. And then we kind of transitioned over to doing a lot of work in WIPO. But there are still a lot of experts that we have around Indian country that are phenomenal in these other fields. And I guess for me, it's, and maybe this is part of my, wanting to help with the National Congress of American Indians where I can in that capacity is like, how do we develop a platform where we know where experts are among Indian country and find ways to get them involved into those different, UN arenas. But, I guess merging technology is one that I would really advocate if there's Indigenous peoples involved in that. It would be very important for us to get more more Indigenous representatives involved in that emerging technology field.
There it is. Thank you. Carla.
I did mention the General Assembly is committed to examining the issue of participation again in the 80th session, which opens on September 8th. So I'll be tuning into that and just seeing what they're saying. Every year they adopt a resolution on the rights of Indigenous peoples without Indigenous peoples in the room. So that's problematic. I think they do it through one of their main committees. The third committee is the Human Rights Committee, and it's super important. And that's in New York City, the General Assembly. So it's a little bit more accessible. The issue is getting your foot in the door because it is the General Assembly and they do have heads of state there. So just the security is really heightened. And that's why we need to have some sort of special status, enhanced status that can get us in those meeting rooms where they're making decisions about us without us. So that's a point that I see moving in the next, I took a break in 2017 and it hasn't moved much. So I'm hopeful that it gets back on track after COVID and that we can get something in my lifetime. And I'm committed to seeing that through. Hopefully beginning this year, it'll pick back up again. Otherwise, I think the permanent forum is a good first step for Indigenous governments who are looking to engage, but don't necessarily know how. And I super appreciate Aaron's role at NCAI. That's a great committee to get some priority areas from tribal leaders. When the World Conference happened, we prepared for that for about 2 or 3 years in advance. So we actually started meeting at NCAI in 2011. We went to the North America Caucus meeting in 2012 with Indigenous peoples from all over North America. And we came with 4 priority points and we shared those with NCAI leadership and they advocated for them. And that was a really great process. So the 10-year anniversary of the World Conference was just celebrated. And we have a lot of work to do, like to implement the UN Declaration and the World Conference Outcome Document. Those are really good jumping off points for tribes to become aware of and engaged with. And I think the permanent forum is a good starting point. But like Erin said, it kind of just depends on what issues are plaguing your nation at the certain point in time. There's no shortage of priority areas for everybody. It's just kind of how can we all work together to push and advance one or two things at the UN that we can work together to change.
Well, thank you so much. We have somehow just run out of time. However, I would like to give both of you the opportunity. If you have any closing words, 30 seconds, we'd love to hear them. Carla and then Erin.
Yeah, I just want to say Nyawako, thank you for everybody on the call today and for inviting me to participate and share a little bit of my great-grandfather's story. It's amazing to see folks aware of his work, and you know, there are some bad sides to it, and it's not easy to, you know, advocate for your people and put yourself out there. So he definitely, his legacy lives on, and I do my best to try to continue some of that work and to make him proud. But yeah, there's good and bad, and anytime you're entering into rights implementation to secure the future of your people, you're going to become a target. And so it's good to have like-minded people around you, and I appreciate that about this panel. Thank you.
I want to acknowledge some of my other colleagues that are out there. So Andrew Goman and Summer Hammonds, who also have been going to WIPO as well. We've had about 8 now, and a late elder. We also had Stan Jones, was someone that would travel with Terry every now and then, or Ray Freiberg. So it's just I just want to say, like, again, for my tribe, I'm just like one person among many, and I just want to help continue that to kind of be passed down to up and coming policy analysts we'll have, and I hope that this kind of goes out more to include other tribes from my region and just from the United States in general, because our voices are really unique, and I think the UN needs to hear them in many of these forums. So thank you.
Thank you both so much for your participation. Thank you to Professor Kristen Carpenter. On this call, we have Linda Benally and former ABA President Paulette Brown. I'd like to invite both of you to give closing remarks.
I'd like to thank all the speakers for just a stellar program. It is probably the first of its kind webinar that the ABA is doing through the UNR. I'm excited that we were able to get this group of people together. With that, Paulette, I'll turn it over to you. Thank you.
Great, thank you, Linda. And I'd like to echo the tremendous, not just the presentation that the panelists gave, but the tremendous work that you're doing on a daily basis. Lauren, you were outstanding as a moderator, and the panelists were exceptional. And I enjoyed hearing, Carla, your personal story. It's very inspiring. But, as I thought about it, Carla, actually, you summed it up. There is still a lot of work that has to be done. And obviously, the best way to continue to do that is continuing your advocacy, and also, working with other Indigenous people from around the world. I'm a true believer in collaboration, and when you have greater numbers, sometimes it can be more effective. But we all know, unfortunately, that Indigenous people have been ignored throughout history and put to the side. So I think that the more we can bring to light through webinars such as this, what's going on with Indigenous people and their right to be heard and to be represented and have not just a seat at the table, but a voice at the table, is extremely important. So I thank all of you for shedding additional light on this, and for all of the participants who joined us today for this extremely important program. So thank you on behalf of all of the UN representatives at the American Bar Association.
Thank you for joining the program today. My understanding is there are going to be additional webinars that are put on by the UNR committee celebrating the 80th anniversary of the United Nations. Thank you all for joining. That is the end of the program.
Great. Thank you, everyone.